hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain...
Welcome back to the next episode of the BC Law Just Law podcast. I'm Tom Blakely. I'm here with Jim Fiore. We're joined by Professor Brodin and Professor Yen. Very fortunate to have them with us today to discuss some litigation that's been in the news. It's former Miami Dolphins head coach Brian Flores' lawsuit against the NFL and a couple of NFL clubs claiming discrimination on the basis of his race, claiming that he was offered money to the tune of $100,000 to lose games as a head coach to improve the Dolphins' draft prospects. And it's really ignited a firestorm across the league. The NFL recently hiring former U.S. Attorney General Loretta Lynch to defend itself, meeting with civil rights leaders. And there's been a lot in the news about this, and so we wanted to talk with a couple of professors who know a thing or two about the topic. We're going to be talking to Professor Brodin primarily about the civil procedure and employment discrimination angles of the case. And we're talking to Professor Yen about the sports law aspects of this. And we thank you both for joining us. Professors, how are you today?
Fine. Thank you for the invitation.
Doing very well. Thank you.
Thank you. Well, I guess, Professor Yen, we'll start with you. Could you just set the scene for us with this case and kind of how we got here and just the environment of the league? It seems like a lot of people are shelling out a lot of money for a lot of lawyers about this. Kind of what's going on here?
Well, first, the NFL has employed lawyers in the past and will in the future, no doubt lawyers who are expensive. I think the background of this is the difficulty that the NFL has had in promoting people of color into head coaching and senior administrative positions throughout the league. Commissioner Goodell himself has said that the NFL's record in this is not what he would like, I guess, to use a euphemism. And Flores, as you suggested, was recently fired as the Miami coach, and he has not yet been able to find another position as a coach in the league. And I suspect that he, like a number of other African-American coaches, kind of felt like it was time to draw some attention to this, and so he sued.
So, Professor Brodin, going to you. So this was filed as a class action suit, and so we have some questions about. Can you just explain what's involved in that? How do you get a class certified? In a business like the NFL, there's only 32 teams. There's only a handful of African-American head coaching candidates. Like, what is involved in assuming you've kind of read the complaint and familiarized yourself with what's going on here? What's the burden for former coach Flores in terms of getting a class, demonstrating he was discriminated against? It seems like a pretty steep hill to climb.
Well, it shouldn't be, because when Federal Rule 23, the class action rule, was amended in 1966, the drafters made it very clear that employment discrimination, indeed any kind of civil rights cases, were the prime expectation that would be litigated as class actions. That's unfortunately changed a little bit, particularly after the Dukes v. Walmart case, which was written by Scalia. He made it somewhat more difficult to litigate a class action under Title VII. And we'll talk about Title VII in a minute. But this case really shouldn't be that much of a problem. Numerosity has been raised as a possible obstacle, but the cases generally say if there are 40 or more class members, which there are here, not named class members, but 40 class members, and Flores purports to represent a large group, that shouldn't be a problem. The other concern, if I were the plaintiff's lawyers, would be commonality, because it's unclear from the complaint so far that the problems that each member of the class, named and unnamed, have are sufficiently common. That was what sank the Walmart class action. But that was a national class action involving tens of thousands of retail stores and hundreds of thousands of employees. This one should be fairly easy, I think, to certify as a class action. I think the complaint has some other problems with it that may make the class action part of it moot. But I think in terms of numerosity, commonality, typicality of the claims by the named members as compared to the unnamed members, and certainly adequacy of representation, this seems to be a law firm that specializes in this kind of litigation.
And following up on that, Professor Brodin, going into more detail about the complaint, what does Flores and the class action want as far as damages or injunctive relief, and how are they going to prove that?
Well, two very good questions, Jim. First, what they want, and this is underscored by a few interviews I've seen with Flores recently, is change. Big change in the league. Of course, for Flores himself, he's looking for compensatory damages. He's looking for the difference between what he would have gotten had he not been terminated and the lost income for the time that he's out. But he seems sincerely concerned about the plantation dimension of the NFL. Now, if I were the plaintiff's lawyer, I might not have used such a provocative term, but this is a very kind of unorthodox complaint to start with. I mean, for instance, it has the F word at the very first line in it. You don't see that in many complaints. So what does he need to prove to get that remedy, which is basically injunctive relief and compensatory damages? You're going to have to prove, and it's not easy to prove, that there was intentional discrimination going on. And intentional in this sense means that it was done deliberately with an eye towards treating people of the protected class differently than people who are not in the protected class. If you credit the allegations, they're well on the way to proving that. But they've got some problems in terms of the statistics because their numerosity does play an important role. They're going to have to get a statistician, if they don't have one already, who's willing to testify that the underrepresentation that's alleged in the complaint is statistically significant. And when you're talking about so few employers, sample size becomes a problem, as Fred knows better than I do, being a mathematician. But it's an uphill battle. There's no question about it. And certainly in terms of resources, the NFL is going to throw everything at it. I had not heard that the former attorney general is now representing them. I find that somewhat ironic. But it's not easy to prove these cases.
But, Professor Yang, go back to you, and you can feel free to jump in on any of that. So one of the measures that the league has, implemented historically to try to, at least do something about this is, of course, the Rooney Rule, which has really become come to the forefront of this case here. Basically, it's kind of gotten to a point where a lot of folks say, look, this is not achieving what we wanted it to achieve. You've got, part of this complaint, one of the most damning elements of it is this idea of sham interviews, this idea that, for instance, the Denver Broncos held an interview with Brian Flores in which he alleges they were drunk and didn't take him seriously. There's evidence of Bill Belichick's text messages to Flores sort of accidentally confirming prior to his interview that the job had already been given to somebody else. Can you talk a little bit about the Rooney Rule and how the leagues tried to address what you pointed out is a pretty challenging issue here in terms of their history with diversity and being able to hire coaches and other executives of color?
Well, the Rooney Rule has its roots, as you suggest, in the NFL's poor record of advancing minorities into coaching positions. The rule states that for a head coaching position, every team must conduct at least one outside interview with a person of color for the job. Undoubtedly, the intention was that if owners interviewed qualified minority candidates, of which there are many, such as Mr. Flores, they would come to realize that these were excellent candidates for head coaching positions and that they would eventually hire lots of African Americans and other minorities as head coaches. That hasn't really happened. The number has remained a bit low. There's obviously a belief among some people out there, certainly including Flores and others, that Rooney interviews are just for show because the league put no teeth behind the Rooney Rule. All that a team would have to do was interview a person of color, and then if they had no interest in that person, go on about business as usual. And I think that's what Flores believes is going on, is that they're just window dressing now.
Professor and Jim, feel free to jump in after this one. Professor Brodin, I wanted to go to sort of what we were talking about just there for a second. In terms of the defendants here, we've got, of course, the NFL, we've got the Miami Dolphins, we've got the New York Giants, we've also got the Denver Broncos who are discussed in the complaint here. And there's separate conduct in terms of each of these organizations. With the Giants, the allegation is that the job was already given to someone else, through the evidence that's offered of Bill Belichick's text messages, basically congratulating the wrong person for the job, basically trying to demonstrate there that this is was a sham interview. The same can be said for the Broncos, alleging that executives were not taking him seriously. They were hungover. There's some other allegations there. And of course, the Miami Dolphins, fired him after he had, statistically and by a number of measures, coached them to a, relatively decent level of performance, given how they have, performed historically, over a number of years here. The team, honestly, in terms of the Dolphins, is a team that has struggled, and Coach Flores came in and had, a good measure of success, to the extent a lot of folks, in the media and in football were really shocked that he would be fired. It didn't really seem like this is, something that had very much to do with merit. And then there's this other claim that, not necessarily related to race, that, is quite explosive, that the owner of the organization paid him to lose to improve the team's draft prospects. In other words, having a lower record to have a higher draft pick. And so all these things are in this complaint. How do you sort of parse out, what claims here, if any, have the highest likelihood of success? Like what is the strategy perhaps in sort of putting this all on the table? Just what are your thoughts on sort of the cadre of things that he's alleging here against these organizations?
Well, it's interesting, Tom, that you mentioned strategy, because the first thing I thought of when I read this complaint, particularly the first few pages, is that this was drafted not with an eye towards the litigation part of it. It was drafted with an eye towards media and public consumption. And my guess is, having gone on the website of the law firm that's representing Flores, it's a pretty flashy website. My guess is that the expectation, and this isn't unusual, but my guess is the expectation is that this will be resolved short of a trial. And if I were the NFL, hopefully short of discovery, because I would think that they would not welcome any discovery into any of these matters, including, throw the game and I'll give you $100,000, which I think must be in violation of some law. So the answer to your question, Tom, is what would the strategy be if it actually was anticipated that it would go through a typical litigation process, motion practice, discovery? There, Flores's lawyers are going to have to very, very solidly build a statistical case, because these class-wide systemic disparate treatment cases are proven or not on the basis of statistical inferences from underrepresentation over long periods of time. This is a kind of classic pyramid situation where everybody at the bottom of the pyramid, the players, and it's kind of ironic because they're not paid modestly in any way, shape, or form, but everybody at the bottom, or 70%, are people of color. And as you go up the pyramid, it thins out considerably and becomes virtually nothing at the top. The typical way you prove that kind of systemic case is to compare the labor market from which the top of the pyramid is drawn against the actual numbers of minorities. And if you do that just on the sheer numbers here, it's a pretty compelling case of underrepresentation. Getting a statistician to testify that it's statistically significant given the small numbers, different story. But there are some kind of red flags in this complaint that make me wonder again about whether this is just a shot at a settlement. For example, you really can't file a Title VII case until you've been to the EEOC and exhausted that remedy. This is the first time I've ever seen a federal district court complaint that says we'll file with the EEOC when we're ready to file with the EEOC. Technically, you need a right to sue letter from the EEOC. I mean, the long and the short of it, together with the fact that Plessy v. Ferguson is grotesquely miscited in this case. For the proposition in the complaint, is cited for the proposition that segregated public facilities are unlawful. Well, I think we learned in the 7th grade that Plessy stood for quite the opposite proposition and was overturned by Brown v. Board of Education. So even though it looks like this law firm has been to this rodeo before, I just have some red flags about it. But the long and the short of it is, if it really is intended to go the full distance, the plaintiff's going to have some difficulties of proof. They're all surmountable, but they're all difficulties.
Could I jump in here for just a moment on some aspects of what you mentioned, Tom? When you mention problems of proof, I think that some of the things you mentioned suggest exactly how difficult things could be for Flores. It's one thing to say, well, it looks bad when Belichick sends you a text that Daboll's going to get the job. Brian Daboll, who has since been named the head coach of the Giants, in advance of Flores's interview with the Giants. But the Giants' excuse is Mr. Belichick was mistaken. He doesn't, right? And how are you going to prove whether Belichick had it right or wrong? That's going to be some artful discovery needed. Again, I believe that the allegations about the Broncos, where they came in hungover and late, but that doesn't mean they did it for any other reasons than they're just buffoons, right? Right? There's the buffoon excuse here, not the discriminatory excuse. And so I think these are right. It to me matches up with Professor Brodin's observation that this lawsuit is not intended to win a lawsuit. It's a piece of theater in the maneuvering to get the NFL to voluntarily change what it does. And even the timing of the lawsuit suggests this. I'm going to do it right before the Super Bowl. So on your most high publicity time of the year, I'm going to take away some of the luster from what you're up to make you folks talk about with the media something that you desperately would prefer not to talk about.
If I could just, sorry, I didn't mean to jump the gun. Just one quick follow-up on that, and then Jim will go. Can you just talk a little bit about, for those who are not familiar with the NFL and maybe not as familiar with sports, just the idea of the good old boys club in the NFL, nepotism in the culture in that league. I mean, you have obviously, and unfortunately there's employment discrimination all over the place, but within the context of the NFL, just the tight-knit network of owners, what people call, the old boys club. How, I guess, strong is that element in dynamic in terms of all this? Because this is not, I think, like many other industries where you don't deal with that. But what is that environment like in terms of these owners and their common interests and the way they could react to things like this?
Well, critics of the NFL would point out that the ownership of the NFL is overwhelmingly white, overwhelmingly male, obviously overwhelmingly extremely wealthy. And so that creates an insular environment where mostly white men who are very wealthy can run the league however they see fit. And so to the extent that that social group does not include a number of people of color, there's the risk of an old boys club that takes care of its own. And that's the allegation that's being made about the hiring and promotion of people of color into senior levels of the league. I think that that's one aspect of it. One can also ask questions about what's the structure and culture of the league itself or the league offices itself, right? That could be separate from the owners. That could also be a subject. I don't think that the NFL league itself, the NFL's offices in New York, are unusually known for their diversity and inclusion. So, obviously what Flores is trying to do is to change this.
Yeah, and you've both mentioned many hurdles that this case is going to face in order to get to trial. I just wanted to talk about one more where it's common for these coaches' contracts with the teams to have arbitration clauses where, if a problem comes up, they don't want to sue, or the NFL doesn't want them to sue. They want to go to a private arbiter. Is that, or Professor Brodin, is the court going to look at that like a forum selection clause, a contract of adhesion? Is that just going to be another hurdle for the case?
Well, I wish that were the case, Jim. And I'm going to defer to Fred on the mechanics of arbitration in these kinds of contracts. But the Supreme Court, over the years, beginning with some decisions by Scalia, have been extremely friendly to mandatory arbitration clauses. Many of us think way too friendly. Congress has at times recently said it would do something about it. I doubt that it will. But what's happening, and I talked to my class about this, is the push towards private ordering. The American judicial system was at one time the envy of the world because you could go into an American court and seek to resolve almost any kind of a dispute. Corporate America caught on to the fact that they weren't doing so well in the courts at a particular point in time. And they now impose upon consumers, credit card users, employees, including football players, these mandatory arbitration clauses. And arbitration is a real step down from litigation. The parties get to choose their judge, and it's usually the employer party that has more say in
that. One other question I wanted to ask here is just something I was curious about that I did not hear, and the media coverage, or a lot of folks have been talking about this, like Professor Yen pointed out. This comes right for the Super Bowl, and it seems like the eyes of the nation turn upon the league. One of the elements here that's somewhat interesting, just procedurally, is if you look at the dates in the lawsuit here, which I believe, and I don't have it in front of me, I believe it was filed like February 1st. This was, very recently. I think it was right there at the beginning of February. Some of the events, some of the evidence that's offered in the case, the Belichick text messages, the Dayball hiring took place January 27th, like towards the end of January. And so you've got just basically a few days there from when events in the case are described to when the suit was filed. And so obviously, people can, work expeditiously to try to bring suits. But there is kind of a question that I had here, just looking at the timeline. It sort of begs the question, was this something Flores was preparing to file? Like, can you possibly prepare a suit like this in that short a period of time, like from the 27th, when you feel like you just got screwed out of the New York Giants job, to decide, okay, I want to file a class action suit, to find a lawyer to write the suit, to file a thing? Or do you think this thing was coming for some time? I mean, I know the Dolphins firing towards the beginning of January was really kind of suspicious for a lot of folks. You kind of thought, well, how did he get fired? I thought they were doing pretty well. I mean, do you and I guess it's maybe a little bit impossible for us to know, at least at this point. Would you say that Flores was sort of preparing to do this from the time he was fired from the Dolphins, or is it plausible that towards the end of January, when he was kind of rubbed the wrong way by what happened with the Giants, decided to sue then? Is it possible to prepare a complaint like this in just a few days, or what do you think kind of happened behind the scenes for Flores here as things played out?
It's certainly possible to prepare a complaint that quickly. I mean, it's pure speculation on any of our part to know when he decided he was going to sue. Since we have some license to speculate, I would imagine that he was obviously angry when he was fired because he felt it was not justified, and he might have wondered if this was because he was a person of color. My guess is that if Flores thought he was likely to be rehired as a coach fairly quickly, whether by the Giants or the Houston Texans or whatever, then this suit wouldn't have been brought. And it makes some sense to me that when he realized that his interviewing was a futile gesture and that in his mind he was the victim of discrimination, that prodded him to go forward. That story makes some sense to me, but obviously I don't know if that's what happened.
I would like to think, but all I can do is think and speculate. I would like to think that there are forces within the NFL who have been on this problem for years, recognizing, going back to Jackie Robinson and Pumpsy Green, that professional sports have generally been extremely exclusionary. And so this was probably under consideration by either Flores or others well before this. But as you say, Tom, I mean, the opportunity to file the case on the first day of Black History Month, after that apparently sham interview, that was probably too much to resist.
So I got just two final questions here. One of them, and I guess they're for both of you here. So Professor Yen noted a little while ago, and Professor Brodin, you talked about it as well. The idea that in terms of the litigation, in terms of the pleading standard here for what we're talking about in this case, there's some pretty precarious challenges for Mr. Flores, but at the same time, given the allegations that are here, the way that this interfaces with the media, and long-standing feelings and quite frankly facts regarding the NFL's record, with respect to hiring and retaining and promoting minority candidates for these positions, there's a strong element of I don't want to call it theater, but obviously there's the court of law and the court of public opinion, and while the NFL could probably possibly win in one of those, it's undoubtable that in the court of public opinion there's a lot of attention now, as there was before, but particularly so now, on what is going on with the hiring of these candidates. So I just wanted to ask about looking at the league's response here. A lot of commentators have looked at the fact that the way the league is responding to this, because the league deals with litigation and the courts and all sorts of issues all the time. But in this particular case, on February 1st, when the suit was filed, the NFL within a few hours releases a statement basically saying there's strong statement. There's nothing to see here. A lot of times the league and teams and just public organizations like this generally will say, oh, well, we can't comment on active litigation. We plan to, et cetera, et cetera. In this case, within a few hours, which I don't think anyone would disagree is an insufficient amount of time to actually determine whether or not there's anything to see here, whether or not there's a factual basis behind these things. Then you have them hiring the former attorney general, meeting with the commissioner and some owners, meeting with civil rights leaders yesterday. This is a very aggressive response by the league to what's going on here. And I'm just curious, is it a matter of politics, trying to appear like you're ahead of the issues? Is it a matter of actually trying to bring about some change? Like, it seems like this response by the league, being as strong as it is and perhaps as strategic as it is, there's something going on Park Avenue within the organization. I'm just curious, from a legal standpoint, just from an organization standpoint, what do you think the mindset could be with respect to the allegations here, perhaps trying to actually do something, or maybe just appear like you're doing something? What would you say about how the way the league responded to this?
I think the league is doing what the NFL always does, which is protect the shield, which to me is protect the image of the league. The accusations that Flores is bringing are among the most damaging allegations one can make about the league. First of all, the league is suggesting not only that it is corrupt in the sense that it employs unfair employment practices with respect to qualified African-American candidates, but in fact that the league is corrupt to its core, that the league does not even offer fair games. Right? So, Flores's initial opening salvo is the NFL is rotten all the way to the games it conducts. And not surprisingly, the NFL is going to respond forcefully to that, right? They want to say, first of all, the games are absolutely on the up and up. We're honest athletic sports providers, and we certainly don't discriminate on the basis of race. That's wrong. So I think that a lot of what you see is going to be maneuvering in the court of public opinion. Now, the other thing that I think is really interesting to wonder about is that I think we would be mistaken to think that the court of public opinion, in fact, renders a singular verdict on this. There are absolutely a chunk of NFL fans and maybe a lot of media that cover the NFL that are willing to criticize the NFL for its inappropriate employment practices. But there are going to be others who view this as simply, Flores playing the race card when in fact he wasn't a good enough coach to keep his job. Again, I'm not saying that that's a correct conclusion to reach about Flores' lawsuit, but there will be people who don't necessarily think the NFL owes him any apologies.
In terms of actual solutions here, we know, as we've discussed, sort of the good old boys club of the NFL, there's a substantial problem that we haven't discussed yet with respect to nepotism and with respect to the fact that, you have owners' kids and coaches' kids that, a lot of these jobs are already spoken for by the time they come available. There's a lot of, dynamics that are at play here that lead to this problem. And then, unfortunately, there's often racism, with respect to this. We talked about the Rooney Rule, but what real solutions could there possibly be? It's really hard to imagine some, litigation or something that a court could do to, besides provide money damages to, potential members of the class that Coach Flores alleges here. What solutions are really on the table for this problem?
Well, I think that's the key question. And one of the things that struck me as I read the request for remedy was this is way beyond the scope of what a federal district judge could do on his or her own, basically restructure an athletic league. Even if it got to the point of remedy, the judge would almost certainly have to appoint a special master, probably several special masters. This is an enormous undertaking with enormous obstacles, because how do you, as a federal court remedy, try to restructure something like this? I mean, the usual remedies in these systemic disparate treatment cases are much more modest. There'll be a prospective injunction, thou shalt not discriminate anymore. There'll be some modest back pay. Ironically, the people who walk out of the court with the biggest bag of money are the lawyers in these class action cases. Not that there's anything wrong with that, but this is an unwieldy request for relief. And again, when I saw Flores interviewed and he said he's all about change, I take that as sincere. But I'm not sure that his lawyers have sat him down and had a frank discussion with him on what he can actually realistically expect by way of remedy, even if he surmounts the hurdles of proving liability.
Let me offer a slightly different perspective here. I'm in complete agreement with Professor Brodin that legal remedy for the court is going to be difficult for Flores to get satisfaction through. It isn't apparent to me that that's the way this is going to work out. My observation of the NFL is it will change when it is in the economic self-interest of the NFL to change. And that one can view this lawsuit as an attempt to bring economic pressure on the NFL. So as a point of reference, one might look at the litigation and the fuss that was brought over the former Washington football team's previous name, which was racially offensive. And for years, despite litigation, to strip the trademark of its registration and whatnot, the Washington football team held out until one of its major sponsors, FedEx, said, well, actually, we may not want our name on your field anymore. We may want out of the deal. And at that point, hey, they caved and they were the Washington football team, now to be the Washington Commanders. It is an interesting question whether American Express or Mercedes or any of the other high-profile companies that sponsor or might sponsor the NFL want to be associated with a league where the public thinks that the league largely engages in discriminatory hiring, right? Because they all have diversity and inclusion programs where they say as companies, that's not what we stand for. If those sponsors said to the league, either we're going to drop sponsorship or, hey, you better change or we'll do something to embarrass you, then I think the NFL might say, well, all right, we got to do something. And that's probably the most realistic way pressure will be brought to bear.
Very good. Very interesting discussion on this case today. And it's obviously going to be interesting not only in the court of law, but in the court of public opinion, what happens going forward with the NFL, with Coach Flores, its record on hiring racially diverse candidates, and what happens for the league going forward here. Professors, thank you both for coming on today, both Professor Brodin and Professor Yen. It's been Tom Blakely and Jim Fiore on the BC Law Just Law podcast. Very great discussion we're able to have today. And until next time, we will see you then. Thank you.
Thanks.